Good morning, Michael Alvarez from Caltech here. Uh, Welcome to our next episode of Election Office Hours. As you may know, this I think is our 14th episode, which is really exciting, and we're getting some really good feedback and getting to a point where we actually getting amazing guests to come in too, and I'm really excited about today's episode. Um, I'm really happy that Justin Levitt decided to join us today. Justin is a professor of law and the Gerald T. McLaughlin Fellow at Loyola Law School here in Los Angeles. He's a nationally recognized scholar of constitutional law and the law of democracies. He served in federal government as a Deputy Assistant Attorney General in the Civil Rights Division of the U.S. Department of Justice. At DOJ, he primarily supported the Civil Rights Division's work on voting rights and protections against employment discrimination. Also, in 21-22, recently, he served as the White House first senior policy advisor for democracy and voting rights. There, within a team devoted to racial justice and equity, Justin assisted the president in his efforts to make sure that every eligible American has secure, reliable access to a meaningful vote, to provide equitable representation in our government, and to restore trust in democracy that deserves that trust, and bolstering avenues by which Americans can build community, engage in civic participation. We also had the great opportunity years back to have Justin here at Caltech. He taught at Caltech, and he was a roundtable expert in one of the first events that our center, the Lynn Center for Science, Society, and Policy, had in May 2023 here at Caltech about the social implications of generative AI. So, Justin, welcome. It's a real pleasure to have you here this morning.
Thank you so much, Mike. I really appreciate the opportunity to be with you. It's a pleasure, as
Thank
always.
And so let's start by talking just a little bit about your path. So can you talk about this path that you've taken, which has gone from academics into government, back into academics, and back into government? I mean, what motivates you to take that kind of path, and what do you learn by being a practitioner as well as an academic?
Yeah, so it's a great question. And to call it a path probably overstates the extent to which the boundaries are clear or planned or anything like that. I was a practitioner before I was an academic. So I came out of law school working for nonprofits, working for campaigns, occasionally working for nonprofits working on campaigns. And decided a couple of years in, I'd had a bit of a chance to teach as an adjunct, really liked it. And in the law of democracy in particular, some of the very practical problems are also really thorny intellectual problems, right? The problems that people are looking to solve have deep roots in deep theory that are actually really difficult, not just practically on the ground, but in terms of even an idea about what the right direction might be, and hotly contested. So it seemed like a pretty natural jump. I was working at a think tank that was already half academic-y, the Brennan Center for Justice at NYU School of Law, and decided to make the jump into teaching. Have loved it. I've been teaching for the last 15 years, and absolutely adore both the intellectual engagement and the time with my students, but never wanted to give up working in the real world as well. And I don't think academics have to, at least if they find an institution that supports that. And I know both yours and mine are very supportive of applied work and keeping a real hand in the real world while also not being afraid to think big thoughts. So I've had the opportunity to keep engaging in litigation, to keep engaging in policy, to keep engaging in real election work with real election officials, and have had the opportunity to represent more than a few, even while serving as an academic. I've prided myself on doing that in a very bipartisan way. I've both represented and sued officials from both major parties and neither, and officials whose affiliation I still don't know to this day, because it hasn't been relevant. Um, and along the way, got some really magnificent opportunities to take leave from Loyola and to go work at, as you said, the Department of Justice and at the White House. Um, that's been spectacular opportunities to not only keep working in the real world, but also to further my academic career. I think my students benefit from the fact that when I talk about these issues, I can point out what actually happened because I was there for a chunk of it. I've been enormously lucky. I am very grateful for the opportunities I've gotten. And to call it a path overstates the degree to which it's really, I do interesting stuff until more interesting stuff comes along. That's been my career sort of profile to date, and it seems to have worked out okay.
So you're nearing the end of your spring semester.
I thought you
What's
were going to say career. That was going to be a really hard needle scratch.
You're just getting started. But can you describe kind of the where your law students are at these days? I mean, it's been a very tumultuous 3 months.
It
And
has.
it's got to be in some ways exciting for law students because there's a lot going on that just every day there's something new that has important implications for law students and for society. But it's also got to be a time where there's a lot of anxiety. So where are your students at in general?
I think you've described it really nicely. Tremendous amount of energy. Not all of it is focused. A lot of it is reactive, and a lot of it is really anxious. And the trick is to try and find a point of stability to channel that energy into action. And it's tough to do when the seas keep shifting.
Right.
The classes I teach are all related to sort of big picture con law, constitutional law, the law of democracy, classes in legislation, how we understand legislation, which are really about constitutional interaction with the legislative process. Those are all courses that are constantly in flux, even in normal times. And we do not live in normal times. The last 3 months, as you say, have been, and I think this is recognizable no matter what partisan preference you've got, have been unusually tumultuous, in part because this president has done a lot of things that stretch the boundaries of what's legal, certainly stretch the boundaries of what's normal, and in a lot of ways overstep the bounds of what's legal. Um, for his supporters, that's a feature. For a lot of other people, that's a bug. Um, Congress has receded from its role as a meaningful check on the president's power, including the president's power over things like fiscal affairs and the budget, which used to be something that members of Congress bragged about when they went home to their constituents, that they were in charge. They've actually taken not only a back seat, they've left the car entirely right now. And that's left the judiciary, the third branch of government, in a very uncomfortable situation. And all of that translates to the students wondering what they can do, how they can do, what role they have to play, both in law school, where we're on a pretty active campus, and so students are engaged from the get-go in the real world, but also in their careers beyond. And I think students are processing all of that anxiety and energy as best they can. There is no question. There's a lot of interest in the topics I teach normally, but especially now.
Right. Well, so this is a great frame to actually dig into the topic that I think you and I wanted to talk about today. So recently, March 25th, 2025, President Trump issued a series of executive orders, including one that could really dramatically reshape how elections are conducted in the US. So let's start there. Can you summarize for us at least what your take is on those executive orders and what they might do?
Yeah, I can do it in 3 words, which is can't do that.
Right.
And expanding on that a little more. So we're actually used to seeing this president take really big swings, sometimes unconstitutionally big swings, in areas of policy where the president has unquestioned authority, either because the Constitution gives it directly or because Congress has given him that authority. So tariffs. President has enormous degree of authority there. Immigration. President has enormous degree of authority there. Um, Moving defense forces around and what to do with the military. The president has enormous degrees of authority there. And the president has used that authority in ways that have caused a lot of questions, right? And the courts have been very engaged in all of these areas and will continue to be, it looks like, very engaged in all these areas because there are real questions about whether the president has used his really big authority in the right way, and whether in exercising this authority he's overstepped some constitutional or statutory guardrails.
Mhm.
The thing that strikes me about the election executive order is that it's a little bit confusing to many people because they're used to these really big swings in areas where the president has authority. And in elections, the president has very, very little authority. And yet, this is a really big swing in an area where the president just doesn't have that much that he's lawfully able to say. That's a disconnect that a lot of people have felt. And I say that as the former senior policy advisor for democracy and voting rights to the president. I spent a lot of my time reminding folks what we couldn't do, um, what's not permissible, either because Congress hasn't given us the authority, because the Constitution hasn't given us the authority, or both. In our system, as you know, as watchers of the webinar know, states have the primary role in election policy. Congress can intercede where they want, and they have in a couple of really significant ways. Where Congress has interceded, it's mostly been by direct regulation. They've handed power over to a few federal agencies in a few areas. There's very little role in any of that for the president because Congress hasn't left a lot of discretion by design. In the tariff zone, Congress has left an enormous amount of discretion for the president to decide flip a switch on, flip a switch off. We're going to impose X or Y tariffs on X or Y country. And that's simply not the case. The permission structure is not there for elections. So we can get into details. Most of my reaction to the president's executive order purporting to restructure American elections, as you say, is can't do that. And particularly, the instructions that he's giving are no different, really meaningfully, than if I tried to order these entities around. I could scribble a note on the back of a Burger King receipt and hand it off to a bunch of other entities around, purporting to instruct them what to do with their elections. And they would take one look at it and say, this is the work of a crazy person. I don't have to listen to this. And in a lot of ways, what the president has done is no legally different in terms of the authority that he's exercising. There are a few things within the executive order that there's actually no question he can do. So I'm not suggesting that just because it's this president with an executive order that it's unlawful. There are parts of the executive order that are perfectly legal. And even where I disagree with the policy, that's still true. But
Let's
the
talking about those though, the ones
Sure.
I think are perfectly legal and within the president's purview. What aspects of this executive order do you think fall into that category?
So there are some global expressions of policy of the president's preferences, what he'd like to see, and he gets to put those out into the world. He gets to say what he'd like to see. Doesn't mean other people have to listen, but that's unquestionably constitutional. Um, there's a provision in there setting high-level policy on which sorts of statutes, which sorts of federal laws the Department of Justice should prioritize. Also, entirely constitutional. He's got different preferences than I might, for example, but he gets to decide that. Elections actually do have consequences, and that's one of the real ones, the permissible ones. He gets to ask, for example, the Department of Homeland Security to produce reports
Mhm.
of various kinds. Go investigate some things and tell me what you found. Totally fine. There's one provision in there in which the president tells the Social Security Administration to open up their records to compare, to help states validate voter registration lists. Um, he gets to do that in part because Congress said the Commissioner of Social Security has to do exactly that 20 years ago. And the Social Security Administration has been doing exactly this for the last 20 years, sort of without note. So that's a portion in the executive order that kind of feels like you're giving a toddler a little plastic wheel to put on the dashboard to pretend they're driving. Like, great, you can order that if you want, but it's already been happening for the last 20 years. Um, then there are some other portions that are a little more controversial. He has a lot of authority to direct the Department of Defense in executing one of these federal statutes, a federal statute that responds to uniformed and overseas citizens, so that helps members of the military, that helps citizens overseas readily get registered and cast ballots that count. Um, there are some questions about whether his direction of the Department of Defense actually sort of jibes with the statute. That's actually a fairly tricky legal issue that'll probably get sorted out in the courts. But at least with respect to, I get to tell the Department of Defense what to do. Most of the time, the president gets to tell the Department of Defense what to do. And the real question is going to be, does this fit the particular statute? But those things that I just mentioned aren't the really big things in the executive order. They're not what the press is focused on correctly. They're not what election officials are focused on correctly. The really big stuff, all differently, falls in categories where the president just doesn't get to decide. Some of them have to do, I'm sure we'll talk about this, some of them have to do with um, deciding what documentary proof of citizenship voters get to supply. Some of it have to do with letting Doge compare voter registration lists from place to place. Some of it has to do with when absentee ballots that are cast get to be counted. None of those things are things the president gets to decide on his own.
Well, let's take them in that order. Let's talk first about providing proof of citizenship when you register, and also providing some form of proof when you vote, proof of ID. Right? They're sort of intertwined, in my opinion, here in this executive order. Why do you feel that those are outside the president's authority?
There are like three or four different reasons. One of them has to do with who he's instructing. One of them has to do with who else is considering the issue. And one of them has to do with the existing statutes already on the books. And I got to point out, none of this has any inherent executive authority. So in this zone, the president is only, literally only operating to the extent that Congress is given permission. And without that congressional permission slip, the president can't do anything in this regard. So that's the backstop. Now, the proof of citizenship, particularly at registration, and that's really the thing that people have focused on, I think correctly, as the biggest swing here. What the president has purported to order in the executive order is that the Election Assistance Commission, an agency set up in 2002 in the aftermath of the Bush versus Gore election, um, to do a bunch of things, including help give out grants, including to help set best practices, including to help local entities sort of reorder their machines and their voting systems, and including designing a federal voter registration form. So he's ordered this EAC to redo the federal voter registration form, the form that voters in 43 states get to use to easily register to vote by mail, converted to online, to require that people submit a document proof of citizenship along with that registration form in order to get registered. The EAC is a curious institution. It does have regulatory authority in exactly one area, and that's this form. Congress said, the EAC, you're in charge of this voter registration form. Congress also said, when it set up the EAC to begin with, you're an independent agency. We're going to make sure that you operate independently of the president. You're in the executive branch, but you're not the same as the rest of the executive branch. No, there are four commissioners that are in charge of the EAC, no two of whom may be part by statute of the same party, showing a little bit of independence from the president. It's always been a bipartisan body. You need three of them to actually do anything. So you need an affirmative vote of three commissioners to act, showing that they're going to be bipartisan when they act, definitionally. And so the president purporting to tell the EAC what to do, first reason that's outside his zone is they don't have to listen. When Congress set them up, it said, you don't have to listen. The president can make a suggestion, just like I can make a suggestion, but he doesn't have any authority to tell the EAC what to do. Even if he did, I don't think he'd have the authority to tell the EAC to do this. So in the last 5 years or so, the Supreme Court has developed a doctrine with actually much longer roots back into the 60s and 70s, that says administrative agencies, executive branch authorities, get to do stuff, but they don't get to do all this stuff.
Mhm.
Congress is the legislator. Congress sets broad policy, and we have to reserve some room for Congress to act. The executive can't step on Congress's prerogative. In a series of cases that deal with something called the major questions doctrine, they've said, we're going to be really skeptical when administrative agencies do really big stuff without what looks like explicit congressional permission. And it's going to be a particular warning flag. This comes from Justice Gorsuch, who's been sort of most forward on this issue. So it's a conservative thing. We're going to be particularly suspicious where Congress is repeatedly considering a really important national issue, that an agency can just go off and do the thing, preempting what Congress is deciding. The Supreme Court, folks will remember, used this doctrine to strike down agency action for vaccine mandates, for climate change regulation, for student loans, all things that they said, no, these are big questions Congress is considering. We got to let Congress do their thing, not executive agencies. Well, it turns out that whether people have to show documentary proof of citizenship when they register is something that's pretty hot button in Congress right now. There's a bill that just passed the House, heavily debated in the Senate. It's not the first time this bill has been proposed. It's pretty controversial. And it would have pretty big effects across the country. And so all of those things are warning signs. The Supreme Court has said, hey, if that's a thing Congress has in front of it, you got to let Congress do its thing. So even if the president could direct the EAC, I don't know that it gets to direct them on this. The last piece of the puzzle is that there's already a statute. This is the statute that Congress is looking to amend that I think pretty squarely prohibits requiring documentary proof of citizenship. And this came up in a tangential way through the courts. It was pretty crucial in a case out of Arizona in 2013. The statute that Congress is looking to amend right now, and the thing that gives the EAC authority to regulate the voter registration form, is the National Voter Registration Act, motor voter. We know it because its main thing is to make sure you can register to vote at DMVs. Does a lot of other stuff, but that was its sort of primary principal public provision. And there was a debate when this went through Congress about whether it should preclude states from requiring documentary proof of citizenship. The Senate said, no, states should be able to do that. The House said, yeah, states shouldn't be able to do that. This should prohibit. We want sort of a smooth, easy path so that everybody gets to use one form to register by mail. They had a fight. They had a conference committee. The conference committee considered this very issue and voted, we're not going to let states ask for documentary proof. There was an amendment in the Senate that the conference committee struck, and both houses voted on it. And so there's pretty clear legislative history in a way you don't often get. I mean, legislation working through Congress gets sloppy sometimes. But here, you've got both houses of Congress that passed this statute voting very directly on whether it was consistent with the statute to require extra documentation when you register. And Congress said unambiguously, that's not okay. So that's the landscape in which the president has said, do the thing that Congress very specifically said you're not able to do. I think that's outside of his proper lawful zone too.
That's a great analysis. Thanks. And so step two here, or part two, is the list maintenance provisions. And in particular, as you mentioned, essentially giving this interesting group, DOJ, the authority and the data to do list maintenance activities on voter registration data. Can you maybe summarize that a little bit? And then, it sounds to me like you think that the president doesn't have the authority to do that. And maybe tell us a little bit about why.
Sure, or at least not yet. So here is something where the president could eventually, maybe, have the authority to authorize federal government to do this. But it turns out we've got a pretty robust infrastructure regulating what federal agencies can do with personal data, due in part to some abuses over time about what the federal government had or tried to do with personal data. The fact that a private entity can collect lots of data from places and use that data for stuff doesn't mean the federal government can do the same thing. There are additional statutes that say even if private entities can go run through a whole lot of data on their own, when the federal government does it, they have to dot I's and cross T's first. They've got to notify Congress about what they're doing. They got to develop a plan. They got to show that the data is secure. They got to say who's going to have access to it and who's not. It's a bunch of paperwork. It doesn't stop the federal government from eventually acquiring and using the data, but the paperwork's important to show that they're being really thoughtful about the process and that there are rules for who gets to access your personal data under what conditions with what safeguards. So this is something where this entity in the administrative state of sort of very contested location and origin and capacity right now. It's something in the courts that is still being litigated. This entity probably could eventually have the authority to review lots of data if states chose to give it. It's a big caveat, come back to in a second. Uh, but they got to do their homework first. And there's no sign whatsoever that this entity has done even a fraction of the homework that they'd need in order to authorize looking at this data and pulling from other sources. DOJ has not acquired a reputation for carefulness thus far in the work that they've done. In fact, they've acquired something of a reputation for exactly the opposite. And there are real statutes that preclude the federal government from just checking stuff out because they're curious. So to the extent that the executive order authorizes or purports to authorize the federal government to acquire data and sort through it, they got some homework to do first. And there's no indication they've done that homework. I actually think that policy considerations and political pressure might be even more of an obstacle to this part of the executive order than the legal bit. As I mentioned, if they do their homework, then they might well be able to get access to this data. But I don't think states are going to be particularly eager to give it to them. We've actually seen this race before. We've seen this rodeo before. In 2017, the first Trump administration tried to set up a commission to very similarly take a look at state voter files and to see what they could find. There were concerns about the accuracy and credibility of the folks involved in that effort, and I don't think those concerns are smaller this time around. If anything, I think they're quite a bit larger. And there were real concerns about the federal government's ability to safeguard the data. And an awful lot of election officials said, we don't want people who don't know what they're doing misunderstanding what the data say and telling us we've got problems that we don't have, communicating that our rules aren't secure when in fact, on a bipartisan basis, we've been working very hard in our states which we're running to keep these rules secure. Mississippi Secretary of State Delbert Hosemann, who is no flaming liberal, told the last Trump administration that it could go jump in the Gulf of Mexico. May or may not be possible anymore, but told them.
But it's the Gulf of America now, right?
Right. Well, so they'd have to direct him to a different body of water. But he basically said, I'm not giving you any of my data because I know I've been administering the rules correctly, and I don't trust that you're going to understand what you're doing enough to do that, to come to a different conclusion. And I don't need you telling me that I've got a bunch of fraud on my rolls and trying to purge people who don't deserve to be purged. And he was far from the only one. There was an awful lot of company of state election officials who said, I know what I'm doing. My staff knows what they're doing. You haven't showed me that you're going to add value here, so I see no reason to give you this data. And nothing in the executive order can tell states what to do. This is really important. Executive orders are orders from the president to the executive branch. They are definitionally unable to instruct anybody outside the executive branch. They can't. They have no power to do that. To the extent that they do, they're suggestions only. And if there's a suggestion here that states take DOJ up on the opportunity to look at the rules, even once they've done their homework, I don't think a lot of states are going to be eager to take them up on that suggestion.
So in the last go round in the first Trump administration, when this happened, was there any? I don't recall any litigation about this though, or was there? Did I?
Oh yeah, the effort collapsed of its own weight before the litigation really reached an end. But there was both litigation in federal court over sort of exactly the same issues, right? Have they done their homework? There's no sense that they've done their homework. Are the people who are involved in this effort even lawfully authorized to be doing this in the way that they're doing it? There was also, curiously, litigation in states about state privacy laws and whether states voluntarily giving up data with a lot of safeguards, right? Lots of people think that the voter file is public, and that's sort of kind of true, but not everything there is public. Social security numbers, for example, aren't public. Some states put restrictions on who can see dates of birth because that information can be private. There are a lot of entries on the voter file that are where addresses, for example, are hidden or changed in order to secure the privacy of state officials or domestic violence victims, right? They're public with an asterisk, and that asterisk has a lot of meat to it. And some states have use restrictions on the voter file. For example, you can't use it for commercial purposes, or you can't use it for anything that's not otherwise authorized by law, on and on. So there was litigation in a few different states um, on not just the federal ability to take the data, but on states' ability to hand the data over.
Okay. But nothing really went very far. So not much in the way of precedent in terms of
Correct. That's
course
right.
of.
It most of that. Some of the state litigation came to a conclusion that said yes, you can give, or yes, you can give under these conditions, or no, you can't give. But I think you're right. There was no sort of thunderbolt saying federally, yes, you can do this, or no, you can't do this. The case is dissolved once the entity, it was called the Pence-Kobach Commission, once it dissolved, once it was clear that states weren't interested in giving the data in the first place.
So the third big piece of this executive order has really big implications here in California. And that's this push to ban the practice that we currently have where ballots that are postmarked or returned on election day, but are not received by the election official until a few days after the election can still be tabulated as long as they're determined to be valid votes. So what about that provision? Do you think is not in the president's authority to compel?
Yeah, so you're right. That's the third big piece, the piece that's gotten a lot of attention and super controversial, not just in California. Um, Mississippi actually had a case in this in the last election. There are a bunch of states beyond California that have this very straightforward rule that says the ballot's got to be voted by election day, right? Nobody's contesting that you get to vote a ballot the day after the election and still have it count. So the ballot's got to be voted by election day. But as long as that's true, it can come in after election day if it's been, for example, put in the mail. And there are a lot of overseas voters who vote by election day, but it takes a little bit of time for the ballot to make its way here. We want to be able to count those. So there are a bunch of states that have this practice. California has it quite a bit. And here, the president's really relying on a kind of wackadoodle decision out of the Fifth Circuit very shortly before the election. The Fifth Circuit is the Court of Appeals, the federal court that sort of deals with Texas and Mississippi and Louisiana, three states. And it says essentially what the executive order says, which is it's unlawful for states to accept ballots that come in after election day. Now, I highlight that because that's a weird outlier. There's no other court that's come to that decision. And there's a really good reason that there's no other court that's come to that decision. And that is the federal statutes saying we're going to have election day have been sort of interpreted for decades to centuries, actually, in some instances, to require the votes to be cast by election day, but not to preclude voting before election day or ballots that arrive after election day. And there's a pretty straightforward normal rule of statutory interpretation in a whole bunch of endeavors, not just in elections, not just in this area, that says if Congress did a thing and a bunch of states have been acting under that in a certain way, and Congress hasn't changed the law to say, yeah, you can't do that, stop that, then we generally think that states are acting in a way that's consistent with what Congress intended. And that's especially true if Congress has revised the law, but not touched the part that states are interpreting to say, don't do that, do something else. Turns out that happened here, particularly in elections around president. Some of you may remember that on January 6th, 2021, we had an attack on the US Capitol, in part created by uncertainty or ambiguity or professed ambiguity around the rules for casting and counting ballots in presidential elections. The form of the code that that ambiguity lived in was called the Electoral Count Act. It's a thing from the 1880s. In 2022, very proud to say I had a very small role in helping to do this. In 2022, Congress passed an update, a long overdue update to the Electoral Count Act. And it revised a bunch of the statutes around casting and counting presidential ballots, including the ballots of presidential electors, and in the process, revised the statute that talks about election day. It changed the statute that we're talking about here. But it didn't touch the fact that ballots cast by election day come in afterward. And under all the normal rules of how we understand statutes, that usually means Congress is fine with it. That what states are doing, including what California's been doing, are complying with, not violating the federal law. There would have been ample opportunity for Congress to say, if it thought that this is what the statute meant, ballots have to be in by election day, right? They're already tinkering around in the engine in the first place. While you're there, it's easy enough to say ballots have to be in by election day, but they didn't. And so I think that the Mississippi case is a real outlier. It's the law in 3 states, but only 3 states. The president doesn't get to decide what the law means. And so he also doesn't have the authority, because Congress hasn't given him the authority, to enforce this notion that ballots have to be in by election day. There's no statute that lets the Department of Justice sue to invalidate ballots, period. But also not invalidate ballots that purport to be casted late. That's a state thing. So the president has said, this is how I interpret the law. And to that I say, great, that's nice. That doesn't have to drive anybody else's actions. There are already lawsuits about this issue in California and elsewhere. And I strongly suspect that the courts will be the last word, that the executive order sort of purporting to say, I have decided, so everybody follow my decision, isn't actually going to be the decision. This is now an issue that's going to percolate up. I strongly suspect that most of the courts in the country are going to disagree with Mississippi. And so eventually we may have the Supreme Court actually weigh in on this issue, not because of what the executive order says, but just because there's now a fight. A bunch of different people are going to read the same statute in different ways. That's what the Supreme Court kind of exists to resolve.
So in addition to those lawsuits, recently the attorneys general from a whole series of states filed some actions to block the executive orders. And I'll have to say, reading their filing was nowhere near as interesting or compelling as your analysis. But what do you what do you think the prospects are here? Obviously, this is going to the courts, right? This is all going to be in the courts for some time. We are in, it's mid-April 2025. The next midterm is really effectively going to be starting in, in the fall and late fall of this year. Do you think that there's any chance that there will be any implementation of any aspects of this executive order before the midterms in 2026?
Very little. So, like I said, the executive order does a lot of stuff. Some of it, I think, is pretty clearly in the president's power. It's the minor stuff. It's not the stuff everybody's talking about. And I think that all gets implemented before the midterms, right? A couple reports get written and delivered to the president. I think the Department of Justice begins to shift its emphasis on which statutes to prosecute, things like that. The controversial bits, I think, don't get implemented. I think they don't get implemented ever, but particularly not before the midterms. I think it starts before the courts, honestly. I think the first question is for the people who are, in some ways, the targets or the recipients of this executive order, the federal agencies that don't have to listen to the president, the state and local election officials that don't have to listen to the president, and the other people involved in the election administration process who don't have to listen to the president. And part of the challenge is helping people understand what power the president has to actually order legal change and when he's just given a speech. And an awful lot of this executive order is just given a speech, honestly. So,
So,
yeah,
no,
sorry.
no, finish, please.
So part of this depends on other entities deciding whether they're going to choose to agree with the president's suggestion or not, recognizing the power or lack of power that the president has to order what he's purporting to order. You're absolutely right that some of this will get decided in the courts, in addition to a bunch of states suing. I think there are four other suits at the moment from nonprofits, some of which have been consolidated. There's a hearing, I think, this week on sort of the very early stages of some of those cases. Um, the courts may come a little bit later, in part because there are technical legal doctrines about when you get to sue and who gets to sue. And those, for me, are actually harder questions in this case than substantively, does the president get to say what he's saying?
Mhm.
First, the threshold questions are, do I get to come into court to protest this? We don't have the option in federal court to just challenge things we don't like in the abstract.
Mhm.
There have to be concrete probabilities of injury, and the right people have to be suing. And here, because the president has purported to order things that people don't have to listen to, it's not clear. Well, there'll be a lot of contest over
Mhm.
whether people have shown that they're injured just yet, because they might have to wait for somebody to listen to the president in order to actually continue these cases. The suits by the states that you've mentioned get to shortcut some of those procedural prerequisites a little bit. So that actually might be the first case that delivers real decisions on the merits of the case, on the substance.
Mhm.
But it might take the courts a little while to sort this out, if only because they'll be waiting to see whether the people whom the president's talking to decide to listen or decide not to listen.
Right. So as someone who's thought a lot about trust in democracy and trust in our processes, procedures, and institutions, are you worried that what might really be going on here is just an attempt to effectively turn the temperature up on concerns about the integrity of elections? This is all going to be in the courts. It's all going to be hotly contested. We're going to hear a lot about it. Obviously, midterm elections, as a political scientist, we know president's party typically does not fare well in those. So does that concern you? Just
Absolutely. And turning the temperature up is a real nice way to put it because the temperature is already red hot.
Mhm.
This president in particular has made a bit of a career. I mean, he's made a bit of a career out of marketing, and he's made a bit of career out of marketing in particular, the notion that our elections aren't trustworthy when they absolutely are and have been repeatedly proven trustworthy. He spent the last 8 years now, he spent the last 10 years now uh, claiming that there's widespread fraud or possibilities of fraud in the system, has shown absolutely no evidence of that in the last 10 years, even when he's made very specific claims that others have proven to be reliably nonsense. Um, by the way, he's made those claims in elections that he's won.
One, yeah.
And I think that now the expectation, whether people believe in those claims or understand them to be nonsense, I think is effectively baked in. I don't know that there's a way to change people's minds on this. If you believe that the UFOs are landing daily and you believe that despite the complete absence of evidence in the last 10 years, I don't know that there's going to be a way to change your mind on that.
Mhm.
So this is now, I think, something of a matter of faith in a small portion of the electorate. I think most of the electorate actually understands, they understand it best for their own local elections, that the elections work. They work to reliably deliver the presidency to Donald Trump, who won more votes in electoral college states consisting of electoral college majority in 2016. Didn't in 2020 because Joe Biden won more votes in the electoral college states consisting of a majority, and then did again in 2024, right? The election process actually three times in three of the most scrutinized elections in American history performed remarkably well. And the 2020 election performed remarkably well in the middle of a pandemic. I mean, that was really a moonshot of an election administration operation. Election officials across the country are heroes for delivering the capacity they delivered in the middle of unprecedented circumstances and did it all remarkably reliably. And so I do worry a lot that this executive order is yet another step in the marketing campaign to try to convince Americans wrongly that the elections in which they participate aren't trustworthy. I don't know that Americans are listening. And that to me, I think, is reason to believe that the efforts won't take root. The conspiracy theories, this is always what happens when you have to keep reality TV more exciting. The conspiracy theories have gotten more and more outlandish. And I think people are starting to cotton on to the fact that they're just outlandish conspiracy theories. We had to wrestle through a notion that Italian satellites were somehow manipulating votes on voting machines cast locally. That sounds absurd because it is absurd. And so I don't know that the marketing is going to land on terrain more fertile than where it's already landed, where it's already taken root.
So that gives me a chance. We have one question I also want to get back to as well. That's in our Q&A. It gives me a chance to talk a little bit about another executive order, which came out recently, which targeted Chris Krebs. And because a lot of what Chris Krebs did and a lot of what CISA did in recent elections was to really fight back against the election rumors and the election myths and the conspiracy theories. Did that executive order, which I'm sure you read, like I did too, did that concern you personally because of your obvious role in some of these administrations working in these various areas?
It concerned me personally because I care deeply about the integrity of the American election structure and because I believe that Chris Krebs did a magnificent job. I don't believe he shares my partisan affiliation, so I actually haven't asked him. But this is wholly independent of his views on policy. I think he did a magnificent job, as people before and after have done, who I know are both members of the same party and not, in helping America reliably have the elections they have and in doing an enormous service to the American public in helping to forestall some very, very real threats and make sure that they didn't affect American elections as strongly as they might have. So they worry me not for me. They worry me because I don't like to see people targeted in a way that feels very authoritarian uh, and not in keeping with the best traditions of this country, for sure. When what they've done is render profound public service, really meaningful public service. Uh, I have seen sort of the executive orders come and the attacks come. Um, and for what it's worth, that's part of the cost of doing business. I'm a little surprised I haven't been named in one of these pieces of nonsense so far. Um, so no, I'm not. I'm not concerned for my own welfare, but I am angry, righteously angry, on behalf of the public servants who managed to make sure that Americans could vote and vote securely and vote reliably for so long, who are now being attacked pretty viciously by the commander in chief because of that public service. That is unfortunately not unique to Chris. He is not the only one to have received the wrath. He won't be the only one. I mean, there will be plenty more coming, I worry. But that's what it ticks me off more than it worries me.
Well, I think that's good to hear. One last question, because I can't believe we've been talking for 50 minutes. I mean, this just has gone by just like in a blur. It's been such a great conversation. But someone in our audience asked if you have any thoughts about the voting technology provisions in the executive order. I believe this is about voting system security and in particular a provision to require VVPATs on voting systems.
So there are two parts of the executive order. One I think is totally fine, lawful, and unproblematic, and the other I think is absolutely out of bounds, but also won't matter. Um, And as you can tell, they're very different. So one asks DHS to review voting system security and to deliver a report. That's the part I think is uncontroversial. Absolutely, the president can order that. Absolutely, DHS can deliver that. Well, they have the legal authority to deliver that. Actually, because of some of the actions that the president and Doge have taken, CISA has been decimated. Their capacity to respond to real cybersecurity threats, much less investigative reports like this, has really been dramatically cut, I think, making Americans worse off. And part of the Chris Krebs, um, part of the circle around the attack on Chris Krebs is a piece of that. So I actually don't know if DHS has the capacity to fulfill the president's executive order now, given the other moves in the administration. But there's no question about his legal authority to authorize that.
Mhm.
Separately, he has purported to instruct the EAC, this independent agency, to review their guidelines for which systems are certified, which systems have gotten the federal stamp of approval of accurate, um, and to decertify machines that don't fit his particular vision of what voting systems should look like. Um, he doesn't get to tell EAC what to do. We've been over that already. Secondly, even if the EAC did decide on their own to follow through and to certify certain systems and decertify others, um, their guidelines are directly in statute and repeated in the name in the by name in the executive order, voluntary. The systems, the advice, the guidance they put out is called the VVSG, the Voluntary Voting Systems Guidance. So voluntary is the very first word. And that means that states don't have to listen. Now, a bunch of states do. And I think 11 or 12 states have, in their own state laws, explicitly tied their own voting systems to the EAC certification. And that's because the EAC advice has been really reliable for a long time now. They've provided good, useful, very professionally competent technical feedback. They have decided which things are risks, which things are not risks. They have sorted fact from fiction and conspiracy theory from real science. They've got a very accomplished board of technical advisors and board of standards that helps them with this work. So states have sort of hitched their wagon to EAC certification, not all of them, but some of them, because the EAC has been a really reliable partner thus far. If the EAC decides to follow something other than the science, and I certainly hope they don't have to, they're an independent agency. If they decide to follow something other than the science, I actually worry about that loss of partnership for the states. But I don't think the states will continue to hitch their wagon to a horse that's running amok. They don't have to. And so I would expect to see if the EAC does something crazy, like decertify all of the machines currently in existence, which the executive order implies might be on the table, um, purports to imply. They don't get to tell the EAC what to do. If the EAC does something like that, I think that unfortunately states will decouple themselves from the EAC and will say, yeah, you know what? Our own state laws, we like the reliable version that we had. We don't need to follow this crazy agency off a cliff. And so I think if the EAC does something that radical, states will pass laws decoupling themselves from EAC decisions and using the machines that they know have been proven accurate and reliable.
Wow. Hope we don't end up in that scenario.
Thank you. There's a lot of federal capacity that's really useful, and I hope that it stays useful.
I agree. The voting system standards have just been amazing. I've seen them develop over the last 25 years to where they're at today. So, Justin, this has been really, I don't want to say fantastic. It's been a great conversation. Some of it is troubling. We're in an interesting era, I think, in the context of election administration and our democracy here in the United States. But thank you so much for your time. And what I really want to do is actually hope that you'll circle back with me at some point, maybe in a couple of months, and we can do an update and just kind of see where we're at in terms of this upcoming election cycle.
I'll hope in a way that there's less to talk about. May we all live in less interesting times than we live in right now.
On that note, thanks again, Justin. It's been wonderful, and I want to thank everyone who's joined us this morning. It's been a really interesting and I think productive conversation. Thank you.
It's great to be with you.